The Fifth Circuit recently ruled that suppressors are not arms and therefore they do not trigger 2A protections. However, now this case is heading to the Fifth Circuit en banc panel for reconsideration, and the plaintiff here just got big help in this critical case. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed. So if you appreciate this type of content, please consider subscribing. Also, just drop a positive comment down below because that helps the algorithm to know that you enjoyed this type of content and that it should send it to more people. Now, as I mentioned in the intro, in this video, we're going to be discussing the suppressor challenge that was recently ruled on by the Fifth Circuit Court of Appeals. This case deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be breaking down is called U.S. versus Peterson. This case involves an individual who had a gun store at his home and it was raided by the ATF. Now, during this raid, the ATF found a single solvent trap that was not registered or serialized. And because of that single item, Mr. Peterson was charged with violating the NFA and was charged criminally. Mr. Peterson and his attorney tried to get that charge thrown out by using a motion to dismiss, and mainly they challenged the NFA as unconstitutional under the Second Amendment. The district court on review denied that motion, finding that the silencers and the suppressors in question are not bearable arms protected by the Second Amendment. However, now this case is heading to the Fifth Circuit en banc panel for reconsideration, and Mr. Peterson just got a new counsel, which is a firm that a lot of people are aware of. They've argued multiple 2A cases in front of the Supreme Court and also other circuit courts, so this is heading in the right direction. Now, the facts around this case are interesting because both the ATF and Mr. Peterson kind of tell a different story. According to Peterson, on June 29th, 2022, both federal and state law enforcement officers executed warrants at his home. This happened in Louisiana, and the local sheriff executed a search warrant and an arrest warrant based on some delinquent sales taxes that were not paid. Now, there was also a federal task force, which was made up of ATF agents and then also 50 other law enforcement officers. The federal search warrant was based on some issues that Mr. Peterson had potentially operated a gun store out of his home and had, failed to do some federal requirements. And the ATF alleged that maybe there were straw purchases, improper record keeping of 4473 forms, and then some other failures as well. They also had issues with some potential firearms that were sold at his home FFL that then arrived and were found at crime scenes. However, out of this entire incident, it was the possession of a single solvent trap that actually got Mr. Peterson jammed up. The ATF found a single solvent trap in his bedroom, in his safe, and again, it was that single item that led to this challenge. Now, on October 20th, 2022, he was indicted by a grand jury and charged with violating the NFA because he knowingly received a firearm that was not registered to him under the NFA. He then challenged this charge and wanted it dismissed based on the Second Amendment. However, the lower court denied that motion to dismiss. That then led Mr. Peterson and his attorney to seek Fifth Circuit review of that denial of the motion to dismiss. Now, the question for the Fifth Circuit to consider was whether the district court erred in finding that the silencers in question are not bearable arms covered by the Second Amendment, or even if so, whether George Peterson's indictment for possessing an unregistered silencer violated the Second Amendment. Now, in the ATF's brief to the Fifth Circuit, they argued first that suppressors are not arms protected by the text of the Second Amendment at all. They believe that the district court got the determination right and that the Fifth Circuit should agree with that analysis. At best, the ATF argues and claims that these items are simply accessories, but as accessories, they are not protected by the Second Amendment. They then argue that even if they are arms, they are still dangerous and unusual items and they can be regulated as dangerous and unusual items. Now, the ATF's last argument for the constitutionality of the NFA's restrictions as it applies to suppressors is that even if these items are protected by the Second Amendment, the Second Amendment right is not burdened by the registration process of these items. The ATF claimed that the NFA process kind of operates as a shall issue permit scheme, and under the Bruin analysis, they believed that that is permissible. They cite to some dicta in the Bruin decision by Justice Kavanaugh where he mentioned that shall issue CCW permit schemes may be permissible under the Second Amendment, but also what the ATF is arguing here is that there is an analog between shall issue CCW permits and a shall issue permit system when it comes to suppressors. Well, the Fifth Circuit ultimately on review sided with the ATF, finding that Mr. Peterson's motion was properly rejected. In this decision, the Fifth Circuit stated that Peterson first challenges the district court's denial of his motion to dismiss. Specifically, he argues that the NFA suppressor registration requirement unconstitutionally burdens his Second Amendment rights. But because we conclude that suppressors are not arms within the Second Amendment's purview, we disagree. They then went on to state that whether suppressors constitute arms is an issue of the first impression in our circuit. And so far as we can tell, every court to have addressed this has decided the question in the negative. Here, the Fifth Circuit looks at whether a suppressor is a weapon of offense or an armor of defense, or is used to cast at or strike at another person. And here, the Fifth Circuit incorrectly finds that they are not protected arms. They state in the opinion that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protections. They cite to his arguments where he states that inasmuch as a bullet must pass through an attached suppressor to arrive at its intended target, suppressors are used for casting and striking at and thus fit within Heller's definition. But the Fifth Circuit said that that is wrong. They state that a suppressor by itself is not a weapon. Without being attached to a firearm, it would not be as much used for self-defense. And unless a suppressor itself is thrown at someone, it cannot be used to cast or strike at someone. While a suppressor might prove useful to one casting at or striking at another, that usefulness does not transform a gas dissipator into a bullet caster. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. They then state that, and whilst possession of firearms themselves is covered by the plain text of the Second Amendment, possession of a firearm accessory is not. The Fifth Circuit then went on to find that a suppressor is not a necessary accoutrement of a firearm that is required to make the firearm useful or functional, and based on that, they upheld the district court's decision. Now, this inherently, of course, is a very concerning decision. The fact that the Fifth Circuit found that suppressors are not necessary and that they are merely accessories brings into the question of what other accessories would a court like this deem are also not protected. Some courts might think that, forward grips, optics, slings, stocks, or even maybe magazines are not necessary for the operation and function of a firearm. So the question becomes, how far does this non-necessary accessory exception actually get taken? And what items potentially are just accessories and therefore could be outright restricted? However, now in this case, Mr. Peterson has retained new counsel from the firm Cooper and Kirk, and they will now seek en banc panel review in the Fifth Circuit. In a recent notice to the Fifth Circuit, his attorneys have requested additional time to file for a rehearing en banc. Since they're now taking up the case and they will need additional time to kind of get spun up on this issue, they have asked for an extension of time. Their original petition for a rehearing was due on February 20th, but now they have asked for an extension and they will have potentially until March 6th to seek that rehearing. So now this issue of whether or not suppressors are protected under the Second Amendment and whether the NFA violates the Second Amendment will head to the Fifth Circuit Court of Appeals and the en banc panel there. We will see if they want to take this up, but even if the Fifth Circuit en banc panel decides that they don't want to review this, that then clears the path to potentially go to the Supreme Court for review of this critical issue. So again, a very important decision. Now it's moving to the next level of review. This is one of those decisions that's really important because again, they're just simply saying that suppressors are accessories. They're not protected by the Second Amendment at all, and therefore the NFA is constitutional. And so we don't want this type of precedent to be sitting, especially in a circuit court that has been pretty favorable to the Second Amendment. The Fifth Circuit has been pretty good on two-way issues. So this is one of those cases that we need elevated to the next level so we can get this decision struck down. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.